Right, welcome to our next panel, which is the Computational Law Update. I'm Harry Surden. I'm a law professor at the University of Colorado in Boulder, and I'm also a affiliated faculty here at the Stanford CodeX Center. By the way, I want to put in a plug for lawyers inventing something. If I remember correctly, the co-inventor of calculus, Leibniz, was a lawyer, so that's something that lawyers invented, kind of important. Anyway, we have a really distinguished panel here discussing computational law, and in the interest of time, I'm only going to briefly introduce them, but I refer you to to the program to see their really extensive list of accomplishments. But starting to my left, I have Bart Verheij from the University of Groningen. Is that close enough? Next, I have Nicole Shanahan, who's not only a current CodeX fellow, but also the founder of Clear Access IP. Next, we have Guido Governatori from Data 61 Cicero from Australia. Next, we have Ron Staudt, who's a professor at the Chicago-Kent College of Law. And last but not least, we have Leila Banijamali from the founder of Startup Documents. Okay, so one natural question that comes up on a panel about computational law is, what is computational law? So let me start out just a few minutes before I throw out some questions to our audience, to our panel, explaining what computational law is. So I want to highlight at the outset that there's actually some terminology confusion about the phrase computational law. It actually has different meanings. So I'm going to lay out two different meanings, and I'll ask our panel how they use this phrase. So the term computational law was coined by Stanford CS professor Michael Genesareth, who's in the back right there. Let me tell you about his meaning of computational law. So this use of computational law refers to one particular approach to legal automation, and that is a rules-based approach to legal automation. In this way, you represent the law and the meaning behind the law in ways that a computer can understand, and the computer comes to legal conclusions about outcomes using deductive reasoning. So a really well-known and widely used examples of computational law in this approach is TurboTax. Many of you are familiar with TurboTax or other tax preparation software. And if you think about what's really going on in TurboTax, there is a representation of some portion of the U.S. income tax code in computer understandable form, and you provide it with facts. TurboTax applies its computer represented laws to those facts and come to a conclusion about your legal liability under the U.S. personal income tax laws. There are other examples of computational law under this approach, things like computable contracts. A lot of financial contracts are of this form, rules-based. I would characterize the systems used by Ron Staudt on my panel, who we'll talk about shortly, as variants of computable contracts. And this version of computational law is becoming more important these days because we're seeing a lot more law embedded in technological systems. So personal research area of mine is self-driving cars, and increasingly we're seeing self-driving cars embed law, the traffic laws, in technological systems because the computers that run the cars need to obey the traffic laws. So that's version one of computational law, the rules-based deductive approach. There's another version which I'll throw out there because people use this, which is the broader use of computational law, and that is the word computation as it's used generally in computer science, meaning just applying computers to some sort of problem. So this broader approach would involve systems that use machine learning, for example, to do document review and predictive coding, and more or less any sort of technological approach in which you apply computation to streamline some legal process or automate some legal process. So this would be automated contract review or things of that nature. So let me just frame those two different views of computational law before I throw it out to the panel. One, the deductive kind of expert system, TurboTax view, and other, the broader anytime we're applying computation to a legal process or the law in order to improve its efficiency. So with that in mind, let me throw the first question out to Nicole. So what do you mean by the phrase computational law? And under your definition, how do you expect, or are you seeing it transforming law or legal practice generally?
Thanks. So I think the first thing I should say, being at CodeX, is that the logical representation of the law is incredibly helpful as a way to learn, because as lawyers and law students, we're trained to write outlines, and that is it is a logical representation, and that can convert into code, an express language, an express computational language of the law. But in my, in practice with Clear Access IP and with the CodeX Smart Prosecution Project, I've found that the best approach is actually a hybrid approach. That logic plays a very important role, but there's also other computational tools that are necessary. And one example is, data mining. So data mining PDF documents is where, I keep running into problems. For example, incident reports produced by police departments. They are in incredibly non-standard image formats, and getting information out and creating a database out of them takes forever. So even if I had really great logical tools to analyze and express, law using this data, the time it takes to get there it just takes so long and it's so painful. I would say that computational law requires us to really think broadly about what the problems are and think broadly about the approaches. But, yeah.
So let me follow up with Guido. Do you have any thoughts about the same question?
Okay, thank you, Amy. So, well, I definitely agree with Nicole that the best approach is where you combine the two different aspects of computational law. So, just to make clear what are the difference between the two, let's say if you can use machine learning and the general approach, data mining, machine learning approach to computational law, well, one of the answers you can get is, yes, I have this case. What is the likelihood that you are going to win that case? And then you get a number, let's say 61%. Now, if we take the other approach and we assume that essentially we have solved the problem of how we get the data in and how to run the system, then the other approach is, okay, I have 61% of likelihood to win the case. But what's the winning argument? How I'm going to argue to win the case? What are the precedents? What are the statutes? What are the article of law I have to use to create an argument, a logically valid argument, which will stand? And because I can provide the evidence and the support for precedent or statutory laws for every step in my argument. So essentially, this is the distinction between the two areas. Machine-oriented approach, where you get some statistical information about your cases and you provide a solution. You provide a quantitative solution, 61%. On the other case, in the other situations, you want to know why. You want to provide the steps going from the premises to the conclusions you have to have. And again, we need both approaches. Only one of the two, it's not enough. Because in some cases, we have too much data, and then we want to use machine learning techniques, data mining techniques, to get the data in a format machines can reason. But then, machines have to reason if we want to use computers for computational law. And this is the tension between the two parts of this discipline. Both are important, and then I would say, yes, we are getting there. We have techniques in both areas that are successful. They can be used. They can be used right now. The real question and the real problem is how to use now in an effective way.
Let me throw out the same question to the rest of the panel for reaction. What is computational law, and where are you seeing it transforming law generally? Bart?
So one thing that I like to emphasize about computational law that is the idea of having a machine that can actually apply the law by computational terms. So think of, for instance, us, humans, we are also thought of by some as a kind of machines, biological machines, and you turn on the judge, one specific kind of human being, and then that judge applies the law. That is a perspective on computational law that I like a lot. And of course, then the trick is to understand computation in humans and in other machines so well that you actually can build them in artificial systems. And that is the idea of artificial intelligence in general. Let's see whether we can build tools, machines that can actually apply the law autonomously. And we know that it's hard, we see that, and especially in the law it's hard, and perhaps we will also discuss some reasons why it is so hard in the law to build machines that can actually apply the law, but that's maybe for the next round.
Any other reactions to that question?
Yeah, I don't really care. I really don't. I mean, what I've been spending my life on is trying to apply technology to improve the delivery of legal services and the teaching of legal services, and what you call it doesn't matter to me.
Yeah, I think that's a good point. Ultimately, we care about, doing some good and improving, and the terminology in some way can get in the way. Continuing with that theme, what are some successful examples of computational law that the panel sees in use today? So let me throw this to Bart.
So you already mentioned TurboTax. That's an area of law, administrative law, that is a very good example of computational law. So for instance, in the Netherlands, we see a system that is like TurboTax, but it's even better than TurboTax because it is government-made. So actually in our country, it is true, and that has to do probably with the fact that also we are a small country. The Netherlands is only 20 million people. The length of the country is less than the distance from here to Los Angeles. And what we have is a system that actually is built for people in order to fill out their tax forms, and there is no question about the validity of what comes out of that system. So, of course, this is only possible because tax law has been designed in such a way as to be very well specified. The questions that are asked are typically very straightforward. How much did you earn? How much do you have in your bank account? What do your children have in their bank accounts? Things like that. And you can specify then the rules of how much money you have to pay. Actually, the slogan of our tax administration in the Netherlands is also something like this. We cannot make it nicer for you, but we can make it easier for you. And they do that by building the software themselves. That applies, let's say, the rules of tax law in the Netherlands to the things that we fill out in the software. And these days, what is a modern development, because every year it is getting better and better, one of the things that is now happening is that even we don't have to answer the questions ourselves. Very few of the questions we have to answer ourselves, because there is actual data sharing. So many of the employers, they are required to send the information about what we earn to the tax administration, and they already fill that out in the forms. So I work at the university. Universities, they have all this information in machine-readable form, and I don't have to fill it out anymore. The name of my employer is in the form already when I download the software, and the amount of money that I made is also already in there. I just have to check whether things have been forgotten, etc., etc. A nice example of computational law.
Thanks, Bart. So Ron, I would characterize your systems that you have in place as successful examples of computational law systems in use today for many years. Can you say a little bit more about those?
Let me start with the first thing. I'm an actual grandparent. And it's possible, being an actual grandparent, to participate in this environment. I'm so happy to be here, and so happy to see so many of you here and standing up in the back. It's delightful. I've been doing this since 1978, and I love it. I'm a technology recidivist optimist, all right? I mean, I'm optimistic about technology as as an impactful way to change the practice and the teaching of law. And I think there's been huge, big, great examples of computational law affecting this world. So at the top in that market, and there are multiple markets, Lexis and Westlaw have been taking $1 billion out of this sector for years, right? And that's a computational set of tools that have helped big law make that $5 million number of profits per partner for many, many years. E-discovery is another example of effective use of computational law to improve the delivery of legal services and to take, to right size or put the right people on the right tasks. There's actually a great new article written by Dana Remus and Frank Levy who say that the effect of e-discovery on the staffing patterns in law firms is much less pronounced than Richard Susskind or Bill Henderson think, and that we got to look at the data and we'll find that some of the right positioning has already happened. In my world, I've been working since I left Lexis in 1978 in a law school setting to try to improve the delivery of legal services to low-income people, and we started by building document assembly front ends. We worked on the UI part of the expert system world, expert systems being knowledge bases, inference engines, and user interfaces. And so we built an interviewing tool called A to J Author, supported in large measure by Jim Sandman's organization, and a little bit of that $4 million a year that has been devoted to help improve technology innovations. And over the period, we built a tool that's been used about 1,200 times to build guided interview tools that sit on a server, also supported by the Legal Services Corporation, that's used about 650,000 times a year, 3 million times in the last 6 or 7 years, for low-income people to find out what their rights are or prepare a document that helps them achieve those rights. So that's a penetration of machine learning, somewhat like what Bart described, that's more generally pervasive in the Netherlands, right? This is just a little segment at that bottom market that has been really quite successful. But we also think that that scale is maybe an order of magnitude off what's feasible. That maybe there are 6 million uses or 16 million uses a year that could be used to help improve the access to justice opportunities that low-income people are facing. So maybe that's a place to toss it back to you, Harry, to see what other people think.
Yeah, thanks, Ron. And I think it's a really good point because we were talking in the last panel about hype and technology and law, but it's important to see real examples where millions of people are being served today by these technological systems, particularly low-income people, and sometimes that doesn't get the attention it deserves. Let me throw the same question out to the rest of the panel. Any other comments on successful computational law systems?
Well, probably I'll take the negative stance here. Yes, I'm not going to deny that those are applications in the legal domain application using technology, information technology. But for me, those are not applications of computational law. They are very, very simple applications. They are very, very complex to build. This is definitely out of question. To build a taxation system, it's absolutely horrible to do it, and similar other systems. Too many variables and so on. But for me, they are not real applications of computational law. There are very, very few real applications of computational law in my view. Some of them at this moment are used for legal teaching. For example, some of the tools created by Kevin Ashley at Pittsburgh for teaching students argumentation, how to argument in legal debates. But for me, again, we are not yet there with real applications where computers have to think. So simulate the reason of legal experts. We are not there. We have the technology. Technology, it's available, but it's not yet used.
Okay, thank you, Guido. And this is an example why the terminology, I think, was important, because different people do think about computational law in different ways. Some people think about it as representing the logic of laws in sort of an expert system workflow, which is a sort of formalization. Other people want the system itself engaging in logical deduction to come to legal conclusions, which TurboTax arguably does in more advanced systems. So, Nicole?
Has anyone seen the manual for patent examination procedure? MPEP? Okay, a few people. It is a almost 2,000-page manual. Just on about 1,000 pages relate to substantive procedure. Just procedure. This is not any of the, there's no case law in this. It's just procedure. So how do you take something like that and logically represent it? It is a massive task, but it's doable. My startup, ClearAccess IP, has attempted to do that just with docketing rules, but if you were to do it with everything else, it would probably be roughly, I don't know, I'm trying to count it up, but within the hundreds of lines of code. It's not that much, I think, if it's written well. Maybe close to 500, but it reduces it down quite a bit. And then what you have then is something that can be applied against a data set over and over and over again and perform certain tasks like compiling files, sending out notices that something is due to the patent office. And it can be used not just in one silo of the patent ecosystem, but it can be used across many, from patent prosecution to litigation to transactions. So I think once you understand how to represent it, you can apply it in many practice areas.
Yeah, Nicole, that's a really good point. I think it illustrates the fact that not everything in law is easily represented in a formal, unambiguous way that can be represented computationally, but some things are. And honing in on those areas, which are sort of the more formal, more rules-based systems, or like you just represented, are real areas of hope for computational law. Anyone else want to weigh in on this question? All right, so
just a quick thing here. I mean, here in 1987, Anne Gardner wrote a PhD thesis and a book. Is Anne here?
She's right there.
Hey, Anne, nice to see you. How are you doing? And basically, she told the story that you're trying to tell now. And the story was, there are easy cases and there are hard cases, and there's the problem with telling them apart, right? And you can use technology, the technology available in 1987, to answer the easy questions, because you can do the kind of thing that Nicole just described with things, and actually Richard Susskind's book says about the same thing, also written in the same year. But the whole question is, can you tell them apart? And maybe we should worry about that, and maybe we shouldn't. I think Guido wants to worry about that, right? I don't really care, because there are 1,300,000 lawyers in the United States that we could throw that problem to, and support them like cyborg-ish, right? With the technology that Nicole wants to provide, and let them do the hard questions and telling them apart, and then go forward and make something better for us and our clients.
Absolutely. I think we're generally in agreement, and Anne's work was definitely pioneering in the field. At the time, we didn't have the widespread technology or connectivity that we do today, so sort of her visions of the past are now, I think, starting to take fruition. All right, so yesterday we had a workshop here at Stanford where we were talking about bottlenecks to computational law. What's holding it back being deployed more broadly than it already is? We've seen TurboTax in a couple of different areas, and one thing I threw out there was this idea of lack of access to high-quality structured legal data. So there's a lot of legal data that's behind paywalls, and even the data you have access to is not human-tagged, encoded, or structured in machine readable form that you could throw various algorithms at it for useful computational work. But I want to throw a similar question out to the panel. In particular, I want to throw it to Leila first. What, if anything, do you think is holding back computational law from more wider acceptance?
Sure, thanks, Harry. First of all, thanks so much for having me. I'm really excited to be here. I've been coming to CodeX for years and years and years, and this is the first time I'm on a panel. So finally, they took notice of me. I agree with Ron. I don't know what, admittedly don't know what computational law means per se, and I don't know if we should be labeling these things because it's constantly changing over time. So I had to do a bunch of research before this event to see, understand and extract the general theme of what I should be talking about. And I think I understand now, and certainly, sitting with alongside this incredible panel, I feel like I have a lot of catching up to do. But I started Startup Documents as a result. It was a bit of a project that was birthed out of my law firm, which I started 6 years ago. It's called Bedrock. It's in San Francisco. It's still active. We're 5 lawyers. It's a tech law firm and represent probably over 800 startup companies, and really saw a lot of inefficiencies there. I still work there. I'm the managing director of the firm, and basically decided to automate the company formation and legal document process for our clients before we opened it up to the public. And, you know, I can talk about my experience with that, and I think that that's where I'll try and stay. So I don't personally see the access to data as a problem when it comes to what we call computational law. I see 2 other larger problems, and the first is that the adoption of technology by lawyers is still very, very slow. So I think that lawyers need to do a better job of empathizing with their clients. It's very, very important. Clients tend to respond quite favorably to lawyers that express an ongoing, sincere, passionate interest in what they're doing. And so we need to really take that and understand how do we return the value back to the client. And that is something that the client is willing to pay for. So that's the first thing. We've seen a lot of law practice management tools. Before I built Startup Documents, I took notes for years and years on what everyone else was doing, and we've seen them come and go. If you've been following CodeX as long as I have, you know, there is a reason why law practice management tools haven't been as successful in law firms. The barrier to entry is very low, but why are the retention rates also very, very low? And that's something that we need to pay attention to. Maybe it's a mindset that we need to change. I don't know. Maybe it's fear of malpractice. I'm not sure exactly what it is, but something to pay attention to. And then the second, we have to determine the value in providing this technology and how we want to dedicate our resources. So for example, if I walk you through a typical process at Startup Documents, a customer logs onto the site, answers a bunch of questions. It's sort of an if this, then that approach. You answer a question in this way, and then the document clauses are generated in, that way. And then within minutes, the document is generated for you. So there is some type of customization, but even before that, there's a human element of it, too, that requires lawyers to decide which parts of the documents should be customized, right? And then once that's done, and the customer applies their electronic signature, the document is ready to be filed. Well, someone actually has to log into the system to do the filing, so it's not necessarily an end-to-end solution, so maybe that's a bottleneck. However, we don't see the value in dedicating our limited resources, our team of developers, to solving that solution, because the cost to us is still the same, and the cost to the customer is still the same. So it actually costs us more if we decided to spend time on that specific problem.
Thanks. That's an interesting reaction. And one theme I heard in your first comment, which has been echoed through lots of the panels, is the reluctance of attorneys to adopt technology as a bottleneck. We've heard, each panel, I believe, has actually echoed this theme. And I think it is interesting to note that some of the most successful examples of computational law, TurboTax, and I'd characterize Ron's as well, were adopted not by attorneys, but by users. So ordinary users use TurboTax to compute their taxes, and Ron's systems are made for low-income individuals who want to have access to justice without having to go through lawyers. Yeah.
So I would like to connect to that. One of the reasons I think why technology is not always adopted by all lawyers is that perhaps the technology is not really ready for lawyers and what lawyers do. So one of my pet slogans is something like this: we need argumentation technology. That's the business of what lawyers do. You argue, you create arguments, you develop the reasons pro and con positions, you are thinking about the case, what is the similarity with past cases, what is the difference with past cases. It's always about specific things in cases. That also connects to the empathy that was mentioned by Leila. And we are developing argumentation technology, and Guido already hinted at that. So in the academic world, there are already all kinds of systems that can be called argumentation systems, but they are not ready yet typically for being used actually in the workplace, let's say. And that's what needs to happen. And I actually personally also believe that if you develop argumentation technology further by looking at what is really happening in the law, so also one of the things that I've been saying to Harry quite often is, don't forget what you do as a lawyer. You should always still love what you are as a lawyer because, well, that's where it starts. You do things typically right, but maybe with computers you can do more and etc. But what we need is to connect the two sides of AI. So on the one hand, I call that knowledge technology, rule-based systems with explicit representations. On the other hand, you have data technology, machine learning, data analytics, things like that, the previous panel. And you need to find ways of connecting those two sides. And I think actually that what you see happening in the law, argumentation, is a perspective on connecting data and knowledge. And just what we need to do is develop, let's say, the foundations, the computational techniques that fit that perspective. And then, perhaps also it is easier for lawyers to connect to the technology. And then things will happen that we cannot predict at all.
So that's a really interesting point, which is maybe researchers and academics are not focusing enough on making the technology appealing and usable to lawyers. Maybe they need a little more empathy towards their users, who are the attorneys themselves.
So a thought about that. I mean, for the people in this room, reluctance of lawyers to adopt and use technology is a problem if you're trying to sell to a product to those lawyers. Otherwise, it's an opportunity that you're taking advantage of, that your firm is organized to run into a space and be more agile and more effective, less expensive, and more appealing to the customer. And if everybody else is reluctant to adopt the techniques that you're adopting, you're going to win, right? And the people in this room can win.
I hope so.
Yeah, I hope so too. The people in this room can win in terms of selling the services that they have to the customer, the B2C business. If everybody else is reluctant, that's a great thing. So the only time you really care about that is if you're Lexis or Westlaw or whoever, or e-discovery people who are selling to lawyers who you need to convince to buy your product, right?
It's a really good point. Guido, do you have some thoughts on this?
Well, I would say, definitely I agree with everything that's been said, but I just want to add. So, one of the problems is that law, it's massive. If you just look, I don't have the data for the US, but if you look in Europe, currently in Europe, in the European community, there are over 100,000 different acts. Each of them is that thick. And then lawyers and the legal professional and people have to know that law. So the problem is, how do we get the data, the legal data, in a format that can be understood then by techniques we can use then to process, provide decisions, analyze, and so on. The real problem is the problem of access to open data. Yeah, the data, it's there, it's available. In Europe, and I would say in the vast part of the world, laws, primary law, it's available. That is the primary data. It's there. But it's not there in a format machine can use. So how do we solve that problem? And then I think that machine learning, natural language processing could be useful in that particular application to get the law in a format then where we can process. And after we can process, we have tools, techniques. Maybe they are not in the best format for lawyers, but can be used by people with some expertise in technology. And then, well, if we have just to build some user interfaces, well, plenty of very good graphic designers to help us to do it. So the problem is, how do we get the data, and do we have enough data to do what we need?
Yeah, I think this is a really important point, which is, so in the United States, one of our problems is access to primary data, case law, statutes, et cetera, in electronic form. But that's not as big a problem elsewhere in the world. But what is a similar problem is legal data in computer understandable and processable form. So a lot of private companies have taken it upon themselves to take primary data and structure it in ways that computers can understand, but that's not from the government. And unless something has the imprimatur of the government, it always has a haze of uncertainty around it. Is this just this private corporation's interpretation of the law, or is this actually the way it is? So I think it is important to get the government on board with publishing primary legal data in ways that computers can process it and not just leave it to the private sector. Any other reactions? All right, so changing gears a little bit here. So a really rapidly rising topic in computational law is smart contracts or computable contracts. And if you look out there on the web, there are projects like Ethereum and R3, which are using blockchain technology to solve certain small aspects, computable aspects in the contracting context. Stanford has its own computable contracting initiative. So let me just throw this out to the panel. What do you think of this computable contracts, blockchain type developments? Where do we see these smart or computable contracts heading? Any reactions?
Okay, yeah.
Sorry.
Okay, well, again, there is a lot of hype on smart contracts. So initially smart contracts were proposed 20 years ago by Nick Szabo as a computer representation, well, a computer implementation of contracts. Well, now in the past few years, there was the idea to consider smart contracts as self-executable programs, so piece of code embedded in a blockchain technology. As you probably know, blockchain is the technology on which Bitcoin operates. However, it's much more extended and can be used for many, many other ideas. And then, well, when we look at those code, those are just a small piece of scripts, and they execute some operations inside the blockchain framework. Now, are those contracts or not? And then if you look at them in the current form, my idea is then they're not contracts, they're just programs. They lack all the characteristics to classify something as a contract. They are not understandable. Well, okay, they're precise and unambiguous because they're program, but they are not understandable, and then we don't know whether they correspond to what human will understand as contracts. So they can be useful. They might be a next step in legal informatics, computational law, but we are not yet there again because at this moment they're just simple programs.
Yeah, I think this is interesting. This is another terminology distinction, and you actually see this. There's a divide in the legal and the technological community about the meaning of contracts. Lawyers understand contracts in one way. Often they understand it as either a formal written agreement or as a series of promises that are with legal consequences, and technologists often understand it differently. I've argued that computable contracts are actually here today. They've been here for years in the financial industry. If you look at typical trades that have been going on in finance, those are actually contracts under the surface for a piece of equity or some sort of security, and they're data structures. They're not written on paper, they're transmitted. They're built upon a written structure like ISDA master agreements, which are English language documents, but the actual day-to-day, what are considered contracts behind the trades are actually pieces of data.
Yeah, big time nomenclature issue here. So smart contracts, computable contracts, very different. And I think like if there's one thing I'd like to leave this panel is the, please know the difference between these two areas. Smart contracts, generally speaking, relate to contracts executed oftentimes on the blockchain, or Ethereum is also a smart contracts platform. And then computable contracts is what Harry just mentioned, and that technology has been around a little bit longer, and I think in the legal tech community is the one we associate with more. One thing about smart contracts, though, and the biggest development that I think has happened here is Ethereum. Ethereum is a blockchain tool. All blockchain is a ledger. It's a ledger of hashes of things that have happened on the ledger. Ethereum allows you to embed information into that ledger. So it's not just a transaction of Bitcoin, but it can be a transaction of something containing many terms potentially. And that's what makes smart contracts in that context really attractive from a legal tech standpoint.
Yeah, that's a really interesting point. So we have a couple minutes. I want to open it up to the audience for questions. We probably have time for maybe 2 or 3 questions.
Hi, Benjamin Grossoff from Coherent Knowledge. One definition or emphasis in contracts are the contingent features. So if you're going to analyze global systemic risk in the financial system, it's all about the contingent provisions in a contract that kick in. And so the financial weapons of mass destruction, the collateralized, the structured finance vehicles that Warren Buffett called that took the global economy down. People didn't have a computational representation of the contingent features. So have there been successful applications of use of technology to be able to reason with or do analysis around the implications of the conditional characteristics of contracts yet? And if not, what do you think the obstacles, or when will that happen?
Any reaction or knowledge to that?
No idea.
So we, at CodeX every Thursday, we see presentations at our weekly meeting from various, projects and startups. And one that comes to mind is this company called DocaSample. It's a startup. And what he did was he tried to create a declarative language. And he even published the library open source. And he said it's really simple. Like any lawyer can, access this library and put in, their key terms and then deploy the code, and then you get this document. And Eddie Hartman was in the room, and he was like, I think you're way overestimating, the technical abilities of most attorneys. But what I think is special about this is that you are seeing kind of these smaller efforts that I think are doing big things in the computable contract space, and figuring out what the language is a big first step.
So I also would like to connect to the question at least. So contingencies is one of the key themes of law. It's all about exceptions, special circumstances, the unexpected. And perhaps that is actually where we need to develop the technology towards. Maybe it's not really there, but there are, of course, many ideas in that area. So there are logics for exceptions, there are the feasible argumentation systems, and et cetera, et cetera. But how do the contingencies enter the actual legal practice? By people applying their common sense knowledge, their analysis of the specific case, their interaction with the clients, etc. And that is exactly where computers are very bad at. Computers don't understand us at all. They have no common sense knowledge. Well, that's my exaggeration of the state of the art. Google and Facebook, they know a lot about us. That's true, in the sense of having data about us, but they don't understand the data. They cannot answer questions about us that go farther than that I have every now and then bought a book on artificial intelligence or something like that. They don't understand the complexities of our lives, and that's where we need to go. So that's also one of my pet slogans. What we don't have is technology that can actually develop complex models of what we are doing and how our society is structured. We do have manual techniques to develop those models inside machines, but we don't have technology that can develop that automatically. The only people that can, the only machines that can develop complex models of our society are we ourselves. And that's, if you want to change that, if you want to have machines that can actually understand our complex society, then you will have to look at how we are doing that. So also one of the things that I like to emphasize.
Apologies
The
for
benefits
that.
of technology.
You know, we're talking about all the things that could go wrong today, and I did not anticipate that one.
Keep your eyes up here, people. Eyes up here. I think we have time for one more question, but just a quick reaction. I don't know in the finance industry if they're doing this, but I knew it is very common in large organizations to model their contractual obligations in internal, like CRM type systems. There's a final question, because I don't want to keep a hungry audience from their lunch.
Yes. If we assume that the law in the future, because of the increase of contacts and international opportunities of interaction, the law of the future will be, to some extent, multilingual. So what will be the role of computational law in this multilingual environment? Thank you.
There are already some tools, in particular in Europe, that are able to build ontologies, and they are built ontologies for multilinguals, and then they're able to translate the clauses and sections of let's say, European law in multiple languages. Well, then let me go one step forward. Well, if we have a logical representation of, let's say, a piece of law, well, then we may consider that the logical representation is the authentic interpretation. And then essentially that might be the future. Again, very, very utopistic, but essentially the logical representation will be the unambiguous representation of the law, and then essentially you have to translate back into the different languages to have more understanding from the people speaking those languages.
Well, thank you. We are out of time. So we have become the most exciting panel of the afternoon. But please thank my panelists for a really interesting discussion here.